Well, for more on this, let's dive right in with our amazing legal panel. Tom Dupree, former Deputy Assistant Attorney General and partner at Gibson, Dunn and Crutcher, and Elizabeth Wydra, Constitutional Accountability Center President. Tom, Elizabeth, thank you. Tom, let me just start with you. We know so very little, but it appears that what we most hope to learn more is the affidavit, the probable cause. How important is that from a legal standpoint, and are we going to see it?
Great question, Griff. And the answer is it is hugely important from a legal standpoint, and I hope we'll see it someday, although I don't expect it would be soon. The warrant itself, as we know, is kind of a form document. I mean, it's almost like a pre-printed form that you fill out with basic information, including the charges the government is investigating, the premises they want to search, the evidence they hope to look for. But the real guts of this, in this case, as in most cases, is in the supporting affidavit. That's the document that Merrick Garland and the Justice Department gave to the federal judge in Florida to justify this search. That document is going to set forth the government's investigation, the specifics, how it knows what it knows, who it talked to, whether it's got an informant, why they think the evidence is at Mar-a-Lago, all of that interesting stuff. That's under seal for now. My guess is someday we'll see it. Certainly if charges are brought, we'll see it, but that's probably not going to happen in the next 72 hours.
No, it doesn't seem. Now, Elizabeth, this obviously, as many have pointed out, an unprecedented action taken against a former president, but also we're seeing that the former president is facing an unprecedented serious charges. Let's break down exactly what he is facing.
Yes, so we do know from the unsealed warrant that there are 3 federal statutes, federal criminal statutes, that the Justice Department has shown probable cause to investigate with this search. So I think perhaps most concerning and the most serious charge for the nation is the Espionage Act charge. And then there are 2 other statutes that deal with the mishandling of government records and the potential obstruction of justice through destruction or otherwise concealment of such records. These are very serious charges, and the fact that a warrant was issued by a court to execute on this search shows that the Justice Department made a case, made a showing successfully that there was probable cause to believe these crimes had been committed and that there was likely to be evidence of those crimes at the Mar-a-Lago site that was searched.
And Tom, the president now indicating that there was this sort of blanket declassification of anything that was taken to Mar-a-Lago. Let's go into that a little bit from a legal standpoint. I mean, what do you make of that claim? How much water does that hold, particularly as we're learning that some of these documents were among the highest of the classified levels?
That's right. And I guess a few thoughts on that. The first is that even if those documents were declassified, that's not necessarily going to be a total defense to any federal criminal charge. The statutes that the Justice Department identified in the warrant application don't all require a showing that the documents at issue were in fact classified. But beyond that, I think what the president is going to need to show is, number one, that he did in fact declassify these documents in the proper way. There's a process that you have to go through to declassify a document. Even if you're the president, you can't just simply declare it's declassified. You have to follow a process. And number two, he also would have had to do that, obviously, while he was still president. A former president doesn't have the power to retroactively declassify something. So the President Trump would have had to have done this on his watch before he left the White House.
Elizabeth, do you want to weigh in on that a little bit?
Yeah, Tom is exactly right. You know, it doesn't matter for the federal criminal statutes whether or not they have been declassified or not. That's not necessarily a requirement. But I do think the level of classification demonstrates the seriousness of the documents that the FBI was able to retrieve with this warrant. And, you know, even if they were properly declassified, and I think there are real concerns about whether they were, the content of them doesn't change. And that content is what is relevant to these federal criminal statutes. And that is what could put the national security of the nation at risk.
And we obviously do not know what was in those documents. Those details are not known, and anything to suggest otherwise is speculative. But let me focus in a little bit on that a little bit. Tom, I'll start with you on this, and that is, if, as Elizabeth points out, that there's such important stuff in these classified documents, then why Why did we get the raid on Monday if they had the warrant on Friday? And does the timing matter legally?
You know, it's a relevant fact. I mean, to me, I was a little intrigued that they got authorization on a Friday to execute the warrant, and they basically took the weekend off and went in on Monday. Again, they had a time window, so I'm not suggesting that the Justice Department acted unlawfully, but it does undermine any argument that this was so urgent that they needed to go, within the hour into Mar-a-Lago. The thing that intrigues me, Griff, is that we know from what the president has said that this began with a long process of negotiation, kind of trying to resolve this dispute, as these types of disputes have historically been resolved by way of compromise and negotiation. But something changed. Something went off the rails. Something prompted the Justice Department to say, okay, enough. Even though he's a former president, we're not going to continue to negotiate with him, but we're actually going to take the extraordinary step of getting a search warrant and executing on it at his house.
And Elizabeth, I'll give you the last word here, just addressing, if you will, your final thoughts, but also sort of how high that bar needs to be legally for things to have changed so dramatically.
I think the fact that a judge approved this warrant shows that the legal bar was met. And then I think, look, it's just a practical consideration that I'm sure Merrick Garland took into account, that we're talking about a former president here. So I'm sure that Merrick Garland, who is a very careful, lower C conservative type of person, was very careful before he sought this type of action. And as Tom said, they went through other steps to try to get this information beforehand. But the main point is that no one is above the law. Powerful, powerless, president, regular folks just like us.
Well, just in the last 10 seconds we've got, do you believe that there's pressure on Garland to essentially fish or cut bait in terms of whether he's going to bring charges or not?
I think he'll follow the law and the facts where they lead. I don't think he is really susceptible to outside pressure, to be honest.
Tom, last 2 seconds. What do you think?
I think he's got to act quickly. The American public need him to make a decision, and they can't dawdle. They have to move ahead.
Tom Dupree, Elizabeth Wydra, thank you very much. Great insight.